Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Last year, when Mr. Koberger stood up in open court and pleaded guilty to all 5 of the very serious first-degree felonies that he was about to stand trial on in Idaho versus Koberger, he waived all of his appellate rights. What does that mean? That means that in the plea deal, the contract that he signed with the state of Idaho, where they agreed to take the capital penalty off the table, and where both sides would not go to jury trial, with the caveat being that with Mr. Koberger's signature on this plea agreement, that there would be no appeals in the future. When Judge Hippler conducted the change of plea hearing July 2nd, 2025, almost 1 year ago, he commented words to the effect, well, we know that under the law, that when someone waives their appeal rights, it's not exactly completely final, citing to a 2019 United States Supreme Court case called Garza versus Idaho. Last year, another defendant who entered into a plea deal, waiving all of his appellate rights out of Texas, a man by the name of Munson Hunter, filed an action in the United States Supreme Court after he pled guilty to charges that he was about to stand trial on and agreed to waive all of his appeal rights. And what happened in the Court of Appeals is that his action was dismissed. It was basically, sorry, you signed this agreement where you said you would not appeal, and so therefore this is binding, and this case is dismissed. He's looking to the United States Supreme Court to interpret Garza. Garza is at issue in Hunter versus U.S., a SCOTUS case, and it deals with what is the scope of appeal waivers that would allow someone who's pled guilty, as Mr. Koberger did in Judge Hippler's courtroom and where Judge Hippler referenced Garza. There's been some conflicts amongst the United States appellate courts across the land as to what exactly Garza meant. There's been some agreement that it means you could still appeal if the defendant can show that he had ineffective assistance of counsel. Another example would be that the sentencing judge in the order of conviction required the person to do more than what the statute for that offense requires. For example, count 1 in Mr. Koberger's case is the burglary count. And under Idaho law, he would be subject to a maximum of 10 years in the state penitentiary for that first count. That's exactly what Judge Hippler sentenced him to. But if Judge Hippler would have sentenced him to, let's say, 15 years or 12 years, that might be a situation under Garza where he could appeal. The Supreme Court accepted Mr. Hunter's, it's a petition for writ of certiorari, and the case has been fully briefed. There's been a number of what's called amicus briefs from groups that wanted the Supreme Court to consider their legal filings. One of the amicus briefs referenced the fact that many times people will plead guilty when they're factually innocent because they fear the unknown of what could happen. March 3rd of this year, the Supreme Court had oral argument on this matter, and both sides, counsel for Mr. Hunter as the petitioner and counsel for the United States as the respondent, went into the Supreme Court building in Washington, D.C., and before all 9 of the justices, they made a final pitch as to why their position was correct. In Hunter's case, he's asking, are there more grounds than what the appellate courts have basically found for someone to be able to still appeal when they've signed away their appellate rights? Of course, the United States is taking the opposite position. They're not wanting any further grounds to be added, and that's exactly what Mr. Hunter is asking. And there's been some discussion that perhaps if there's a violation of due process, perhaps if there's manifest injustice, perhaps if there's an issue addressing contract law, plea agreement is a special form of a contract, things like that. We are awaiting a decision from the Supreme Court on Hunter. There needs to be a majority, 5 of the 9 justices, whether they're voting in favor of Mr. Hunter or in favor of the United States. Finally, there's been a lot of discussion regarding what is an Alford plea. That is a form of a defense that when a party has been brought up on whatever charges it is, that they acknowledge that there is enough evidence for the prosecution to make it quite possible that they will meet their evidentiary standard, their very high burden of proof, which is beyond a reasonable doubt. And so the person is basically recognizing that if they go to trial, there's likely going to be a conviction, but they're not actually standing up there and pleading guilty like Mr. Kohberger did, although it's taken as though it is a guilty plea. We will continue to keep you posted on the matter styled as Hunter versus United States. Until next time, this is Kathy. Thank you for joining us here today.